Welcome to the Deep Dive. We take complex sources, break them down, and give you the key insights fast. Today we're looking at something really tricky. What happens if you have a foreign criminal conviction, maybe from, a questionable court, and how that affects your ability to enter or stay in the U.S.?
Yeah, our goal today is to unpack that.
Yeah.
How does U.S. immigration law handle these convictions right now? Why is that sometimes a problem? And what are the proposed fixes? It's really about looking past the document itself to see if it reflects actual justice and what that means for real people.
Right. We've got a great source for this, an article from the Notre Dame Law Review by Jeff Sebula called The Problem of Foreign Convictions in U.S. Immigration Law. It gets into the weeds on what conviction even means in this context. So let's unpack it. Okay, so maybe we should start with the basics. How does the Immigration and Nationality Act, the INA, actually define a conviction?
Well, on the surface, the definition in the INA seems pretty straightforward. It talks about a formal judgment of guilt entered by a court, or situations where guilt is found or admitted and some kind of punishment is ordered.
Okay, simple enough.
But here's the kicker. The law doesn't actually say it has to be a U.S. court. And, courts have long accepted that foreign convictions can trigger really serious immigration consequences. Things like being barred from entry, being deported, or losing eligibility for asylum.
Wow.
And for you as an applicant, this means you absolutely have to disclose any prior conviction on your forms, like the I-485 for a green card. No exceptions.
But that leads to this really difficult question, the one Judge Posner brought up. Are U.S. courts really supposed to just accept a conviction from a foreign system that completely lacks basic fairness? He called it a kangaroo court to make kangaroos blush. It just feels wrong, doesn't it?
That's exactly the problem. I mean, the courts and the BIA, the Board of Immigration Appeals, they have occasionally said they could disregard a foreign conviction if the system was, fundamentally inconsistent with an American understanding of fairness. But it's rare. And crucially, there's nothing explicit in the INA itself that requires them to check for fairness in foreign convictions.
So there's a gap.
A big one.
Okay, so why should we question these foreign convictions? I mean, beyond the gut feeling that it's unfair, what are the solid legal arguments for allowing U.S. officials to look deeper?
Well, one big argument stems from the history behind the 1996 Immigration Reform Law, ICAR. When Congress expanded the definition of conviction back then, they were really focused on a domestic issue. They wanted to stop people from using things like deferred adjudication here in the U.S. to avoid immigration consequences.
Ah, okay. Like the Oscott case showed.
Exactly. There's just no sign that Congress was thinking about blocking scrutiny of convictions from totally unfair foreign systems. That wasn't the target.
That makes sense.
Yeah.
And you mentioned precedent earlier. There's actually a Supreme Court case that seems relevant here.
Yes, Small v. United States from 2005. It's really interesting. The court looked at a firearms law that mentioned being convicted in any court, and they ruled that any court actually meant only domestic courts.
Only domestic. Why?
Partly because of a general assumption that Congress usually makes laws for the U.S., not the whole world, but also, and this is key, because foreign legal systems can be, and I quote, inconsistent with an American understanding of fairness.
So even though the INA does apply to foreign convictions, Small suggests Congress might not have really grappled with this kangaroo court issue when they wrote the definition.
Precisely. It casts some doubt on whether the broad definition was meant to cover absolutely everything, no matter how unjust the process.
And there's another layer too, right? About how courts sometimes read exceptions into the law.
Right. The BIA itself has done this, like in the J.M. Acosta case from 2018. They ruled that a domestic conviction that's still under direct appeal doesn't count for removal purposes. And they cited fundamental fairness as the reason.
Okay, so if a U.S. conviction on appeal isn't final enough because of fairness concerns.
Exactly. Then how can we logically say a conviction from a complete sham trial abroad, which is arguably way less fair, should be automatically accepted? The fact that Congress didn't explicitly say check foreign convictions for fairness shouldn't mean we can't inquire when faced with something deeply unjust.
This idea of scrutinizing foreign judgments, it's not totally new territory for U.S. courts, is it?
Not at all. There's a long history here. We can look at two areas for sort of analogies: international comedy and extradition law.
Okay, let's take comedy first. What's that about?
International comedy is basically about respecting the laws and judgments of other countries. So U.S. courts generally do uphold foreign civil judgments, but they balance this respect, this international duty, with protecting the rights of people under U.S. law.
So there's a limit. You wouldn't enforce a foreign judgment if it's totally against our own laws or policies, or if it was obtained by fraud.
Right. Exactly right. And most U.S. states have laws saying they won't honor foreign judgments from systems that don't meet our standards of due process.
Hmm.
Now, immigration consequences are technically civil, not criminal, but everyone acknowledges they function like a severe punishment.
Yeah, deportation is a huge deal.
Right. So if a foreign conviction leads to that, shouldn't we ask if honoring that conviction is, repugnant to basic U.S. policy and fairness?
That seems logical. What about the second area, extradition law?
This often comes up with in absentia convictions where someone was convicted in another country without even being there for the trial.
Tried and convicted while they weren't even present.
Correct. And many U.S. courts, going way back to the 19th century, don't treat these as final convictions for extradition purposes. They see them more like mere charges and require extra proof of guilt before sending someone back. Even the State Department's own manual, the FAM, says an in absentia conviction shouldn't count for blocking someone's entry to the U.S. unless the person had a real, meaningful opportunity to participate in their defense.
But wait, this creates a potential contradiction, doesn't it?
How so?
Well, you could be protected from extradition because the U.S. considers your in absentia conviction unreliable,
Right.
but then turn around and be deported based on that exact same unreliable conviction in an immigration case.
You've hit the nail on the head. It's completely incoherent. It allows an end run around the extradition process.
Right.
Both comity and extradition show a clear U.S. policy. We don't have to honor foreign judgments that are fundamentally unfair or just don't reliably show guilt. That principle should apply in immigration, too.
Okay, so let's say we agree we should look closer at these really suspect convictions. How do we actually identify a kangaroo court or travesty of justice? What are the practical signs?
Well, the language used by courts is strong. They talk about proceedings falling below standards accepted by any civilized system or being a parody of justice. It's a high bar.
Definitely sounds like it.
But we can point to concrete things. The source uses the Doe v. Gonzalez case as a good example. This involved a conviction during the Salvadoran Civil War.
What were the red flags in that Doe case?
Several things. First, just terrible defense counsel. Doe's lawyer barely tried, didn't present evidence, didn't cross-examine, focused on other defendants.
Wow.
Second, the judge's behavior showed a real lack of concern for the law, like not even instructing the jury properly.
Okay.
Third, the verdicts and sentences were all over the place, inconsistent, suggesting Doe was singled out unfairly. And finally, you had credible outside observers, like a UN Truth Commission, flat out calling it a simulated trial that was rigged from beginning to end.
Those are pretty damning indicators. It paints a very clear picture.
Absolutely. And the source also makes a good point. The INA already has an exception for purely political offenses. And that exception is defined to include situations where convictions were obviously based on fabricated charges.
So the idea that fabricated evidence can invalidate a conviction for immigration purposes isn't totally new.
Exactly. It's already there in the law, in a way. It just makes common sense. A conviction based on lies shouldn't count for anything, especially not something as serious as deportation. It's not reliable. It's not just.
This all makes sense from a fairness perspective. But what about the practical side? Would asking immigration officials and judges to evaluate foreign court systems place too much burden on them?
That's a fair question, but probably not significantly. The key is that the initial burden, the responsibility to raise the issue, would fall on you, the non-citizen. You'd have to come forward with pretty strong evidence showing the foreign process was truly fundamentally flawed.
So it's not like they'd have to investigate every single foreign conviction that comes up.
No, not at all. We're talking about the really extreme cases, the especially egregious miscarriages of justice. Most people with foreign convictions wouldn't meet that high standard.
Okay, so it's targeted. It's about preventing the U.S. from basically rubber stamping outcomes that are just completely unjust.
Yeah.
How would it work procedurally?
It probably wouldn't need huge changes. If you're applying for a visa, you could submit documents challenging the fairness of the foreign conviction. The State Department could update its Foreign Affairs Manual with clearer guidelines for consular officers.
And an immigration court.
Similar process. You, the non-citizen, would present your evidence about the unfair trial. DHS, the government, would present its side. And the immigration judge would make the call. Was this foreign proceeding so flawed that the resulting judgment doesn't actually count as a conviction under U.S. immigration law?
And immigration judges, they're used to dealing with complex legal stuff already, aren't they?
Oh, absolutely. They do it all the time. They analyze intricate legal questions. They look into the details behind convictions for things like aggravated felony findings. They examine why convictions might have been vacated later on. They consult detailed reports about conditions in other countries. Looking at a foreign court record, maybe some proof of corruption or bias, that fits right into the kind of work they already do. It's feasible.
So, wrapping this up, what's the big takeaway for you, the listener? Our deep dive suggests that even though the INA's definition of conviction looks really broad on paper, there's a strong argument that Congress never meant for the U.S. to be forced to accept verdicts from foreign courts that are, frankly, shams.
Yeah, and it's more than just legal definitions. It really gets to core U.S. values of fairness and justice. By saying there needs to be some minimum level of fairness and reliability for a foreign conviction to have such drastic consequences here, we make sure our immigration laws actually align with those values. We only punish people who are genuinely guilty, not just those who got caught in a broken system abroad.
It's fascinating, isn't it? How something that seems so clear-cut a conviction can have so many shades of gray once you look internationally. It really makes you consider what justice truly means, and whether just having a piece of paper from a court somewhere else should automatically determine someone's entire future in this country. What part of this discussion stands out most to you?